These two police officers in St. Petersburg, Florida, arrested this homeless man for trespassing. He was never convicted, but he was taken on a ride, which resulted in him being paralyzed and a double amputee.
Alberto.
Huh?
What are you doing?
Oh, I fall asleep.
Yeah.
You want to have me ticket?
No, you're going to take the ride today.
Huh?
I think after a certain minute, there should be a felony after a certain amount.
I do too.
After a certain amount of any crime, there should be a felony.
Keeps coming in contact.
Yeah.
Doesn't change his ways. What can we do?
Come on, Roberto.
The family of this homeless man just filed a civil rights lawsuit against the city of St. Petersburg. The lawsuit filed in Tampa federal court on Monday says that Heriberto Sanchez Mayan, age 61, is seeking damages in excess of $75,000. I would hope so. The lawsuit names the city of St. Petersburg and police officers Sarah Gaddis and Michael Thacker as defendants. According to the lawsuit, Sanchez Mayan was not secured to a seat in the jail transport van, so a sudden stop sent him flying and knocked him unconscious. He sustained injuries to his cervical spine, which paralyzed him and resulted in the amputation of both legs above the knee, according to the lawsuit. Neither police officer involved here has faced any discipline. Both of them are still employed by the St. Petersburg Police Department. I have the body cam footage here. Let's go through it. According to the lawsuit, Sanchez Mayan was unlawfully detained and placed under arrest by Officer Gaddis on June 8, 2023, for trespassing on private property on the 200 block of 15th Street North. Body cam footage provided by the police department shows Sanchez Mayan sleeping on a cardboard box in an open green space before he is woken up by Officer Gaddis. In the video, Gaddis appears to recognize him as she addresses him by his first name and asks what he's doing there.
Hey. Yo! Alberto.
Huh?
What are you doing?
Oh, I fall asleep.
You know you're trespassing out here, right? Is this yours?
No, that's somebody else.
Put your shoes on. You can come over to my car. I'm going to write you a ticket, okay?
Okay. All right.
Actually,
Put my shoes.
Officer Gaddis can be seen on video calling for a police transport van, and that's when St. Petersburg police officer Michael Thacker arrives. And he gets out his chains.
S41 is the van here, by any chance? Hey, can you come over to 251 15th Street and S41? It's going to be a trespassing on B15.
Oh, you know my ticket?
Yeah, come on over to the car.
Okay.
You got everything that's yours?
Huh?
You're leaving your beer cans behind?
That's all mine.
Yeah, right. That's the one you always drink.
No.
Yes. Yeah, no, it's right next to you. Plus, you always drink those.
Yeah, but that's not mine.
Could you please zip up your fly?
Huh?
Zip up your pants. Do you see this sign right here? You see it? Can you read
Oh,
what?
no, I didn't see it.
What's that say?
No, that's not.
Do you know what it's? Okay, so you know that you're not supposed to be here. Which way did you come in?
Huh?
Which way did you come into this park?
Just, I don't know.
Did you walk in from this way or did you walk in from that way?
Go that way.
All right. Well, there's a sign over there
I
too.
didn't see it.
Well,
It's all right.
can't be helped. Can't be helped. Go ahead and drop your bag. You got anything in there?
No, it's nothing. It's nothing.
Just drop it down. You're fine. Drop it on the ground. There you go. Let me get some gloves. How are you? You got anything in your pockets?
Get my cigarette.
Take them out.
Get my telephone.
Huh?
My telephone machine.
Okay, put him down there. Anything else?
Nothing else.
Put your arm up. Gotta make sure. Oh, you got more stuff. Pamphlet.
Oh, that's what they got.
What is
Like,
that?
by the church.
Okay. Chinese church?
Yeah.
Okay. No drugs or nothing?
No.
Okay. Nothing in your shoes?
No, nothing.
No?
No.
Oh, you got a hernia, huh?
Huh? Yeah.
No. Okay. Yeah.
You have me ticket?
No, you're going to take the ride today.
Huh?
I've decided that you're going to actually go to jail today.
Oh,
I've had
no,
far
please.
too many problems with you.
Please, have me ticket.
No, absolutely not. We're getting all kinds of complaints. Can't be doing this. Okay? So
No.
he's coming now, and then he'll take you out.
Shoot, I'm gonna.
Have me ticket, please.
No. Come on, let's go over here. You get tickets all the time. You don't care. You don't change your ways. Right here is your stuff.
Heriberto. That was first name.
Mayan Sanchez. I'll get it for you, Becker. James still in here? What is in there? Come here, Dad.
Put your handcuffs in front, okay? Put your hand in your waist. What's he gonna charge with?
Trespass.
Potato trespass?
Yeah.
I think after a certain minute, this should be a felony after a certain minute.
It
I do
should.
too.
After a certain amount of any crime, it should be a felony.
Keeps coming in contact.
Yeah?
Doesn't change his ways. What can we do?
A year in jail would probably settle it.
What's that?
A year in jail might solve it.
Yeah.
Maybe. It's debatable.
The officers load Sanchez Mayan into the police transport van, which had no seatbelts or safety restraints. They are shown on the video throwing the rest of his belongings conveniently into a nearby dumpster. But they did at least save his cell phone and a couple of his documents.
All right.
Escalating.
It's a nice phone.
You guys good?
Thank you.
Why do you stance for me? Why do you stance?
Yeah.
Yeah, let's go.
Just this bag of stuff. It's like food in there.
Nice.
Does that thing stink?
Yeah.
What's it smell like?
Leo.
Throw it away. I'm pretty much done. We'll take the soil and stuff to them.
Yeah.
If they don't need it,
It's all soiled.
yep.
And
We don't need it.
There you go.
Throw it I'm going to take care of you guys now.
Thank you, sir. Appreciate it.
According to the lawsuit, Officer Thacker then drove this van in a reckless manner at an unsafe rate of speed and made a hard stop for what his lawyers believe was a red light. A video recording provided by police shows Sanchez Mayan slide across the bench that he was sitting on, fall and hit his head on a metal partition that separated him from another man being transported. Officer Thacker noticed on his video feed from the back of the van that Sanchez Mayan was lying face down on the floor, but did not pull over, according to the lawsuit. But he continued to drive to the Pinellas County Jail. When Thacker arrived at the Pinellas County Jail, he opened the doors and he noticed Sanchez Mayan's body was limp. Thacker started to shake him vigorously and said, "Wake up," several times. But when he didn't wake up, Officer Thacker is shown on video trying to lift him up to wake him up. When that doesn't work, Thacker then grabs him by the feet and he drags him, feet first, out of the van. Video footage shows that in the course of dragging Mr. Sanchez Mayan out of the van, Thacker moved his head, which caused Sanchez Mayan to strike his head on the bumper and again on the ground. Shortly afterwards, the video shows that Sanchez Mayan was attended to by medical personnel and then taken to the hospital by ambulance. According to the lawsuit, Pinellas County dismissed the criminal trespassing charges against Sanchez Mayan because the property where he was arrested didn't have no trespassing signs in the proper places. So what is the law here? At the point at which this man was put into handcuffs and other chains and then put in the cargo van that they put him in, really the Fourth Amendment no longer applied. Now we are under the 14th Amendment. Really, I see two major claims here. One is excessive force under the 14th Amendment, and secondly, a deliberate indifference claim regarding the medical needs that he had. Let's talk about excessive force first. So excessive force under the 14th Amendment is a little bit different at the point at which we are, which is at the pretrial detainee stage. So it's basically an objective reasonableness standard. It's a little bit different. So this is 11th Circuit case law, which applies in Florida where we are here. Considerations such as the following may bear on the reasonableness or unreasonableness of the force used. 1. The relationship between the need for the use of force and the amount of force used. 2. The extent of the plaintiff's injury. 3. Any effort made by the officer to temper or limit the amount of force. 4. The severity of the security problem at issue. 5. The threat reasonably perceived by the officer. And 6. Whether the plaintiff was actively resisting. Just on the law, the plaintiff here would win on all of these. Because if the breaking of the van was a use of force, if the facts are determined that the breaking of the van was purposeful in order to injure this individual, we're going to meet every single one of those factors because it's going to be unreasonable because no force was required. There was no active resistance at all. It was just a malicious use of force to punish or hurt somebody. If those are the facts, and that might be a jury issue, of whether the breaking was purposeful, it's very easily going to meet the excessive force standard under the 14th Amendment. Now, the other claim is going to be even better and easier here because we don't have to prove that there was this intentional use of force. A jury could believe that the officer indeed had to brake and it wasn't his fault, there were no seatbelts, and he just never noticed that the guy was injured in the back of the van. Jury could believe all that, and the plaintiff could still win on these facts under the deliberate indifference standard. So what is that standard? So under the 14th Amendment, if the plaintiff can prove he had an objectively serious medical need, so he was injured, and that the driver of the vehicle, Officer Thacker, acted with subjective, deliberate indifference to that serious medical need, and that the plaintiff suffered an injury that was caused by that wrongful conduct. A serious medical need is one that's been diagnosed by a physician as mandating treatment, or one that is so obvious that even a layperson would easily recognize the necessity for a doctor's attention. So here, according to the lawsuit allegations, Officer Thacker had a video monitor showing the inmate or the pretrial detainee in the back of the vehicle. So as we see in the video footage that would have been available to him, the inmate is unconscious apparently on the floor after he hit the brakes. Yet he continues driving to the Pinellas County Jail. Any layperson could have realized at that point that there was a serious medical issue occurring and that he needed medical treatment as soon as possible. Even if the braking was a complete accident or coincidence, this man did not get immediate medical treatment. The only defense to that is that Officer Thacker just failed to even observe the status of the people in the back of his van. And if he certainly knew that he hit the brakes. So if he knew he hit the brakes and he made the deliberate choice not to check on the people in the back of the van whom he knew did not have seatbelts or other restraints, then there is a textbook deliberate indifference case there. And remember that with each of these claims, not only do you have to prove a constitutional violation, but you also have to get past qualified immunity. And in order to do that, you need to point to prior case law, either U.S. Supreme Court or out of the 11th Federal Circuit, theoretically placing police officers on notice that the conduct they're engaging in is unconstitutional. And so I did some research, 11th Circuit case law. There was a case from 2020, Patel versus Lanier County, Georgia, where the claim is basically this guy Patel was left in a police vehicle for like 2 hours with the windows up and it was too hot. He ended up hospitalized after the fact. They didn't actually make it past qualified immunity on the excessive force claim because the facts are just a little too unusual. But the 11th Circuit did deny qualified immunity to the police officers in that case, just based on the vehicle being too hot. So again, that was 11th Circuit controlling precedent for this jurisdiction. That was 2020, so well before this occurred. So the police officers could be denied qualified immunity in this case just based only on that Patel case. And there could be more. You can only spend so much time, and you could spend weeks trying to find an identical case. But that is a pretty close one. That should deny qualified immunity in this case. So hopefully we'll have an update at some point throughout the litigation process. Sometimes these federal Section 1983 cases can take up to a year or a year and a half to litigate. And actually, that is very, very quickly. So thanks for watching. Please subscribe, both here and at the blog at thecivilrightslawyer.com. Don't forget to follow me on Twitter at JohnBryanESQ, especially if you like completely unrelated history stuff. If you have a video you want me to review, use the submission link below. And congratulations to the Institute for Justice on their argument before the Supreme Court this week in the Gonzalez versus Trevino case. I really look forward to hearing or reading the court's opinion in that case. And so now's a great time to donate to the Institute for Justice. The link is also below. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.